Good day, and thank you for joining the discussion. My name is Dick Aaron. It has been my privilege to have the insolvency curriculum as my assignment at the law school for over the past 50 years. Probably because I have lived on the verge of it most of that time. The question which Lori posed to me is, how will this pandemic change the legal landscape? Okay, let's stay with the landscape metaphor. It's pretty obvious for the insolvency bar that it's like Hurricane Katrina off the shore of New Orleans. How hard will it blow? Who will be left standing? Will the dikes hold? All that we know is that the waters will rise in every quarter. Consumer bankruptcy in Chapter 7. The individual with a repayment plan in Chapter 13. Farm bankruptcy in Chapter 12, especially amongst the dairy farms. And of course, the main impact will be in Chapter 11, reorganization of business. We should also expect municipal bankruptcy in Chapter 9 to increase, and the nonprofit segment, which are not subject to involuntary bankruptcy. Colleges are vulnerable, and there has been a rise in hospital bankruptcies even before this crisis. And this is a global pandemic, so the surge should appear in cross-border insolvencies, the subject of the newest edition, Chapter 15 of the Bankruptcy Code. But I would like you to look at some legislation of the past few months, which bears directly on what should be coming. Congress took some steps which turned out to be fortuitous just at the end of last year. Congress created a faster, cheaper, small business reorganization. It's called Small Business Subchapter V, or Roman numeral 5, which took effect on February 19th. It's cheaper because the debtor remains in charge, although with a standing trustee. There is a relaxed conflict rule, so existing counsel can remain. There is no absolute priority rule, which gives veto power to the lender. Those who urged its passage, the American Bankruptcy Institute and the National Bankruptcy Conference, said it would benefit 50% of the small business in Chapter 11. Keep that estimate in mind when, as part of the Coronavirus Relief, Aid, and Economic Security Act, the CARES Act was rushed into effect in March. Congress tripled the cap of those businesses eligible to $7,500,000. The CARES Act also extended the maximum time for a Chapter 13 plan when modified. It's extended to 7 years from the current maximum of 5. Payments made by the CARES Act are excluded from the definition of income and disposable income in the Bankruptcy Code. And you recognize those definitions as critical to determining who has access to Chapter 7 and the length of time needed to get a Chapter 13 plan confirmed. The most profound change is not found in the bankruptcy section, 1113 of the CARES Act. It is the Payroll Protection Plan offering loans to business to keep employees. Now, DIP financing is the signature of Chapter 11 reorganization. It's the export to the commercial reforms in Europe, Russia, Japan, other countries around the world. And please, let's remember Madison's comments in the Federalist Papers. So the refusal by the Small Business Administration to even accept applications from small business in Chapter 11 has been met with lawsuits in Vermont, Delaware, Texas, and elsewhere. From a law professor's point of view, this is a wonderful policy debate. It could keep us well into the night. It's also an icicle. And it's in the 80s outside of my window. That issue will be moved quite soon. I've only had time to mention a few of the headline questions. We haven't even discussed mortgage foreclosure, student loans, and many other issues. Thank you for letting me share some of my experience with you.